case on the docket.
I'm not going anywhere, I'm just stretching.
Nice to meet you.
Thank you, Marshall. Guess I'm the only one tough enough to hear all of them. Gentlemen.
Morning. Still morning. You may be seated. All right, the last case on the docket is JOANN HARRELL and Barbara DAKE versus Charles A. Badger et al. There's 20 minutes per side. I would assume 5 minutes rebuttal time unless the appellant tells me otherwise. Are you okay with the 5 minutes?
5 minutes is great.
Okay, you may begin when ready.
May it please the court, my name is Bob Wilkins. As the court's aware, I represent the appellants, Barbara Dake and JOANN HARRELL, in this action. In preparing for the oral argument, it struck me that the appellee has taken really inconsistent positions in this underlying action. On the one hand, the trustee has argued that there's absolutely no evidence to support the claim that the trustee breached any fiduciary duty. And on the other hand, he seems to concede that point and to argue that he didn't comply with the statutory requirements for decanting a trust because he relied on assistance of counsel. And therefore, yes, I did commit a breach of trust, but I'm exonerated from liability for that breach. It seems to me, as to the first issue, the record doesn't support a claim that there was no breach of duty here. Let me give you the court example. There was a court order requiring this trustee to file semi-annual accountings in 2006 forward. He never did that.
And after the failure to file the first semi-annual accounting, how long did it take for you, as the attorney representing the appellants, to motion the court to enforce that rule, or did you make an attempt to do that?
We never did that, Your Honor. My client did write a letter in 2009 requesting the court to order that accounting. She didn't ask me to file that petition, and therefore she was told the case is closed. We're not entering any further orders in this regard. But that doesn't obviate the need for the trustee to comply with the court order. I mean, whether we ask the court to hold him in contempt or not is a different question from whether he was required to do it. And in addition to that, even if he didn't file it semi-annually, under the trust code itself, he had a duty to do it annually. And as this court's Nye versus Nye case says, you don't ever start any statute of limitations if you've never accounted. So the fact that he never accounted really leaves his issue open for future litigation, because you don't ever start the statute running until you account.
Were any of the accountings filed prior to you initiating the litigation?
Well, first of all, I didn't initiate the litigation. The trustee initiated the litigation. The trustee filed a petition for judicial settlement around 2011. And we responded to that. We responded by when he basically disclosed by affidavit that he had decanted the trust. He never filed an accounting. The only accounting he ever filed of this trust was in 2007, and he never served it on anybody. And his lawyer didn't file it. He himself filled it out, stuck it in the court file, and at that point we didn't have electronic filing, so it didn't come to me. It didn't go anywhere. It just sat in the court file. Never was served on the beneficiaries, never was served on David Wilson, never was served on my clients at all. And so that I think is an important point, because you talk about, I'll give you an example. You can have a breach of fiduciary duty and have no damages. The accounting is a classic example. If a trustee fails to account and fails to account for extended periods of time, as happened here, that is clearly a breach of fiduciary duty. It is the fiduciary duty of the trustee to account. That's one of their primary duties. Now, once they're compelled to account, it may turn out everything's fine, that there are no damages. But the mere fact that they breached their duty to account on a timely basis, and in this case in accordance with the court order and the trust code, means he had a breach. And that's the important point to make here. Now, let me focus on the next issue, which is the decanting issue. The statute came into play in 2007 when the trust code was amended. Chapter 736 was enacted and it replaced Chapter 737. Under that trust code, there was a specific statutory provision that allows decanting of trust, but you have to follow the statutory formula. The statutory formula says, number one, it has to be a trust that's eligible for decanting, and the only trusts that are eligible for decanting are trusts in which the trustee has the absolute power to make distributions. The statute goes on further to say that an absolute power is not a power limited by ascertainable standards. In other words, if you have the standards that you see in almost every trust agreement, health, education, maintenance, and support, if you have those standards in your trust agreement, you may have discretion as to those four things, but you don't have absolute discretion beyond those four things. And the statute specifically says those four provisions, health, education, maintenance, support, are ascertainable standards. If you've got those in your trust agreement, you can't decant, period. There's no authority for it at all. And that's exactly what happened here. Now, one of the things that he also did not do as part of the decanting is he never gave notice to anybody. That's also a statutory requirement. Even if this trust had been eligible to be decanted, he had to give notice to the beneficiaries, and he could not decant for 60 days until they were given an opportunity to object to his proposed decanting. Again, what happened in this case, we got notice after the trust assets were decanted in 2008 and were ultimately squandered and dissipated by 2011. In the course of less than 3 years, we went from $216,000 of trust assets to zero, and never got notice that this had even happened. So if the court is going to look at that statute, there's a clear breach of duty there. He didn't decant a trust that could be decanted. He didn't give notice that was required to be given. If that's not a breach, I don't know what it is. It's absolutely a breach.
Counsel, I'm not sure that I agree with you on whether this trust could be decanted, because it says that a power to invade principal for purposes such as best interest welfare shall constitute an absolute power not limited to specific or ascertainable purposes. So it seems to me that if you have those things in there, the statute construes that to be absolute power and allows the decanting. But I do agree with you that the statute's clear that you've got to have 60 days prior notice. And it seems to me that there's one other problem here. It says the beneficiaries of the second trust may only include beneficiaries of the first trust. My understanding is here, the beneficiaries of both trusts were Mr. Wilson, but of the first trust were your clients, and the second trust was some, I don't forget the name of it, but some entity that turned out to be hocus pocus.
The community. Here's the way those trusts work.
Well, laying aside how the trust work, I'm just trying to focus, am I correct that the beneficiaries of trust number 2 were not the same as trust number 1?
True.
Okay. And the statute, you and I may disagree on one of the elements, but there were 3 elements, one of which we may disagree on, but the other 2 elements, you got to give 60 days notice to the beneficiaries, and the beneficiaries have to be the same.
Correct. And let me go back to your first point, though. If you look at the terms of the trust agreement, here's what it says. My trustee shall have the full power and authority exercisable in their sole and uncontrolled discretion to pay to or for the benefit of my son for his support, maintenance, and education, or to meet emergencies such as illness. It doesn't ever say those broad terms that are giving you the absolute power. This is a classic ascertainable standard case. This is exactly what you put in a document if you want ascertainable standards. And it doesn't allow them to go beyond that. That's it. Those four things. And it's health, education, maintenance, and support. That's what it is. And if you read the statute, it's clear those kinds of ascertainable standards do not allow you to decant the case. Now, unfortunately, from a timing standpoint, it appears that when we filed our appendix to this brief, the initial brief, we wanted to include the Florida Bar Journal article. I'm assuming the court could have retrieved that article, but there was also, and we filed it this week, an article in the action line, the reptile section's action line, by an attorney a few years ago, back in 2013, that wrote an article about, you can't do that, you can't decant that. One of the things that she pointed out is exactly what happened here. This is her example.
That's not part of our record, though, below. You're just giving...
No, I'm arguing from a substantive
I
drawing.
guess I was misunderstanding. You're sending us articles to put in the record to read?
This was an article that was done in action line. It was part of the appendix, because I wasn't sure the court had access to this particular
Well, what I'm
reptile.
asking is, you're sending us articles that people are writing saying you should look at this as part of the evidence or part of the record?
Part of the argument, part of my argument. Yes.
Okay.
Here's the example that's given.
Well, the trial court didn't have the benefit of that part of the record for your argument in the trial court, correct?
No, that's not correct. The court did have that. That was an attachment. I gave the court a trial brief that had these articles were all in that brief. And it should be part of the record in the trial court. This article was in the list of things I gave the court at the time of trial. But I don't want to belabor that point. Let me just give you the read. It says, for example, if a qualified beneficiary for whom the requisite notice was not provided, that's our case here, is subsequently apprised that a decant occurred which eliminates the beneficiary as a qualified beneficiary of a trust, theoretically said beneficiary could object to the decant well after the expiration of the notice period. Such objection could lead to an undoing of the decant or a surcharge against the trustee for breach of fiduciary duty. That's our case. That's the example. That's exactly what we're doing, what's happened here. Let me also take a moment to just outline the other issues in this case, and that is
So you asked the judge below for a $216,000 or so surcharge against...
we wanted the trust reconstituted, yes. We wanted $216,000 put back into the Rita Wilson Trust, testamentary trust. That's what was improperly distributed. What the Special Needs Trust...
That was what was pled below?
Absolutely. We wanted that trust reconstituted. That was what was pled below. And there was a bond in place that the prior judge had required on Mr. Badger to ensure that if he did anything that breached his fiduciary duties and caused damage to the beneficiaries, that bond was there to cover us.
So what happened to that bond?
Well, it's been discharged now, but...
Been discharged as a result of the trial judge's ruling below?
Yes. So I believe it gets reinstated if this court reverses. I think that's the law, but don't want to...
So if we reverse by your position and we reverse and say the trustee, in essence, owes $216,000, you're saying that there would be a surety bond that could then be reinstated to,
Yes.
in essence, replenish what has been
Yes.
taken away?
Yes.
Okay, go ahead.
Either that or...
Would the trustee or the bonding company be able to show that of the $216,000, some amount, I don't care what amount, X, whether it's some or all, was spent for proper purposes?
I have no idea.
No, I'm saying, not can they, but are they, theoretically, would they be able to come in and say, okay, even if we decanted improperly, the money would have been spent anyway because we spent, so much for his medical care and so much for this, and so it would have all been gone, or 90% of it would have been gone, or whatever the number is.
It depends on when you determine the breach. The surety bond is there to cover damages for breach of duty. The breach of duty occurred in this case when they decanted the entire amount to a stranger. That's what they did. It would be no different than the fact that I take these funds and give it to the next guy on the street. Whether that guy decides to spend it on the appropriate beneficiary or not, I don't think is relevant. The issue is, when did the breach occur? It occurred when he decanted.
Is there evidence below that the trustee of the second trust actually took any of that money and provided for the care of Mr. Wilson, or did they just simply take it for untoward purposes?
Well, there was some testimony, and we do have some testimony in the record, that one of the things that, we know a couple of things. Number one, Mr. Badger testified that he got paid a bunch of fees out of that 216. His lawyer was reimbursed, he was reimbursed, there was a number of fees that came out of that, none of which were approved by the court at any point in time. In addition to that, what happened in this case, and this is what was so horrifying, is the trustee apparently paid almost $60,000 to acquire and to upgrade a mobile home in a mobile home park, and then allowed the mobile home to be foreclosed because it didn't pay $250, $300 of lot rent. Never notified us because we weren't beneficiaries of that second trust. We had no way to protect, we could have protected $60,000 of investment in this trust. So what's happened is, I think the total the trustee got, or caregiver, got around $30,000 or $40,000. We got $60,000 that we dumped into this mobile home that got foreclosed. So there's $100,000 flushed on those two things alone. And the whole point of this trust was to maintain David Wilson. If you look at what was spent on David Wilson's maintenance by this trustee, even though he was not doing it out of trust assets, he was paying it out of his own pocket and showing it as trust disbursements, it didn't cost but around $7,500 a year to maintain David. And now we have this situation where they take and flush $216,000 from January 2008 to 2011, 3 years. They flushed $216,000 down the drain.
Counsel, you're in your rebuttal time, just to let you know.
Thank you, Judge. I will reserve my time. May it please the Court. My name is Alex Douglas, and I represent Charles Badger, the appellee. He was the trustee below. The key issue in this case has not even been mentioned, and it was never mentioned by the appellant in his initial brief, and that is whether the trial court was proper to rely upon Florida Statute 736-0816(20). This statute provides that a trustee may employ persons, including but not limited to attorneys, and act without independent investigation on the recommendation of such persons.
Are you suggesting, therefore, that that statute essentially indemnifies a trustee, that says that a fiduciary duty is essentially delegable, or that it creates a sort of an indemnity if you hire a lawyer or an accountant or some other licensed professional, that you're completely off the hook?
Your Honor, what I'm suggesting is the legislature has already, as a matter of public policy, decided that if an error has been made by a trustee who has diligently sought out professional advice, we're going to put the blame on the professional and not on the trustee. It's a public policy decision, and it's exactly why Judge Perry below found in favor of Charles Badger. And there's a very similar case, Wool versus Lee, Louis, which is out of the 3rd District. We cited that in our answer brief. And it finds basically under almost an identical statute, but in the probate code, that where a personal representative hired an accountant, and that accountant advised a personal representative in filing a 706 estate tax return to take a marital deduction, that was later disapproved by the IRS. The court found that the personal representative under the similar probate statute was not liable because the PR is not an insurer of the trust assets. So to answer you, Judge Orfinger, on this, the legislature, as a matter of public policy, through enacting 736-081620, has already decided that the trustee who's called upon to administer a trust is not the insurer of the trust assets. In situations where they have hired a professional licensed by the state of Florida, vetted by the Florida Bar, to give advice on a very highly technical, complicated issue, such as what we have in this case.
In this case, the appellee acknowledged that the order appointing him as the trustee required him to provide the semi-annual accountings beginning in August the 16th of 2006. Is that correct?
That's right, Your Honor.
Okay, so you're also saying that even though the trustee was well aware that the semi-annual accountings needed to take place, chose not to do them, offered no explanation as to why they weren't done, and then hides behind the advice of the lawyer defense, and you believe that absolves him from any liability, correct?
Your Honor, that's not correct. There is record evidence with regard to, and I can cite it in the record, where Charles Badger was asked exactly what you have noted here, and this is at record transcript at page 294 and page 274 to 275. Charles Badger explained what he understood his responsibilities were based upon the advice of Mr. Geismer, his first attorney, and that is that he was not a trustee until he had that bond put in place. Now, it took him substantial time to find a bonding company. He went through 3 or 4 bonding companies until he found someone to bond him, not because Charles Badger, who's a 24-year veteran scientist at the Florida Department of FDLE, thank you, Your Honor, but because there had been litigation between Mr. Wilson and his sisters. Mr. Wilson filed an action to remove his sisters because they cut off the electricity in the house that he was living in, his mother's house, in an effort to get him out. And they were feuding and fighting. And so Mr. Wilson basically came to his neighbor, Charles Badger, and pleaded with him to please help me in this situation. This is a situation where Charles Badger reluctantly became involved in this situation to help his neighbor.
Following the hearing on August the 16th of 2006, did Mr. Badger then make decisions and disperse funds under the trust to care for Mr. Wilson? Excellent
question, Judge Wallace, and the answer to that question is there were no funds. The trust was illiquid. The only trust asset at the time that Charles Badger became trustee was the home. And the home was not sold until January 2008. So for almost 2 years, Charles Badger pulled out of his pocket $19,000 to make sure that Mr. Wilson could live and would not be homeless. And so the accounting that he did, that he filed 2 months after he got the bond, which he understood there wasn't any duty to file accountings until he got the bond, because he wasn't trustee until he got the bond, which is what he testified he understood from his counsel. At that point, he showed all of the money that he expended out of his own pocket and put on his credit card for the benefit of Mr. Wilson. Now, when the home was sold in January 2008, he never got the first dime from that sale. He never touched any of the trust money. It was wired directly into the Florida Foundation, which is what his counsel, Ms. Littlefield, had told him to do. he went to Miss Littlefield, who, of course, is now in prison along with her husband, to do a special needs trust. Why? Because his prior counsel, Mr. Geismer, suggested this would be appropriate for someone like Mr. Wilson, a gentleman that his sister testified was diagnosed with paranoid schizophrenia when he was a young boy. So he went to someone based upon a recommendation of a trusted colleague that she had used and had a great experience with her with regard to a special needs trust, and said,
Yeah, okay, let's say he did all that, and the Littlefield said, all right, here's what you need to do. You know, we're experienced in this area of the law, and we do this all the time. Just give us the $216,000. We'll look after Mr. Wilson, and you'll be fine. And your trustee did that. And then the Littlefields, let's say under my hypothetical, 15 days later took that money and went to parts unknown, stole the money. You seem to be saying, consistent with how you responded to Judge Orfinger earlier, that because they went to see a lawyer and the lawyer gave him that advice, and then he followed that advice, that the legislature has deemed that an absolute defense or an indemnification, or whatever term we want to use, to any trustee liability.
that's right, Your Honor.
What's your best case what case law says that in your?
Well, there is no, other than the Wool case that looks at the similar probate statute, we have not found any case in Florida that says that. However, we have done extensive...
Follow up while you're answering. Why wouldn't the situation be, since you didn't give him the 60 days notice, that your client breached his duties as trustee, but let's give him the benefit of the doubt, he relied on this criminal advice or bad advice or whatever term we want to use from the Littlefield side, but his claim's really against the Littlefields. He did breach, and there's been damage as a result of that, because the money's all gone.
I would disagree, Your Honor. Again, this is a public policy issue that the legislature has already weighed in on. If you're going to be a trustee in this state, you have the protection of relying upon your professional advice without further investigation. We're not the only state.
They become the de facto trustees.
No, no.
Because if there's anything that goes wrong in the administration of the trust, the actual trustee's defense is, that's all the lawyer and the accountant, they did it, I didn't do anything wrong.
Well, that's what the third DCA found in Wool, that the personal representative had relied upon erroneous advice from his attorney with regard to a marital deduction that the IRS found we're not going to allow. It caused damage, and they tried to surcharge the personal representative, and the court said no. Under the Florida Probate Code, you're allowed to rely upon your professional advice without further investigation, so long as, and in that particular case, so long as it's in good faith. Now, Your Honor, I think that if you take any situation to an extreme, you can get some extreme examples. But one example would be if the trustee knew that what the professional attorney was advising was fraudulent or was illegal, then in that situation, or was collusive, that's a situation where the trustee should not be allowed to rely upon the statute. Now, the statute doesn't give those exceptions, but from a public policy standpoint, if the facts of this case were different, and by the way, there's absolutely no facts in here that would support that the trustee did anything other than an absolute good faith in the belief that he was doing the right thing by the beneficiary.
One of the documents he signed when he went to the Littlefields office was this personal care contract.
Yes.
Where he's identified as the patient, I think, and his wife is the caregiver. I mean, the guy can read. You've told me he's a scientist for 20-something years with the FDLE. I mean, how can you say this is in good faith when he signs this contract that misidentifies the parties and who the care is being provided to and all of that?
That's an excellent question, and Mr. Badger answers that at the transcript, page 278 to 278 to 780. I think I might have gotten the numbers wrong on that, but he addresses the fact that, one, this was incidental to the Special Needs Trust. The care agreement was not the focus of the transaction, of the reason for hiring Ms. Littlefield. The focus was to set up a Special Needs Trust, and he brought everything that the Littlefields would need to examine the situation of Mr. Wilson. He brought the will, he brought over all the receipts and things that he had done so far for Mr. Wilson, and so the gravamen of the professional advice was to set up the Special Needs Trust so that Mr. Wilson could qualify for things like food stamps and other government assistance without being disqualified by a support trust. The care agreement was solely because Mr. Badger said, look, Mr. Wilson needs transportation to the doctors, I need to take him on occasion to the grocery store, things like that. And Ms. Littlefield said, well, you need a care agreement that sets forth what you're going to be paid to do that. It is true, Judge Warfinger, that it included other things, such, I know appellant has said, such as giving him housing and stuff like that Mr. Badger testified, yeah, there were some things in there that I wasn't doing for him right now, but I thought...
Didn't that agreement even misidentify who the party was that was both providing the care and receiving the care?
I don't believe so, Your Honor. If that was the case, that's a new issue that I haven't heard raised. But if that is the case, it was certainly not. It was certainly a scrivener's mistake, one of which everyone involved, including Mr. Wilson, knew what the situation was. And to
Mistake that it provided $25 an hour for the services of Mr. Badger's wife to provide the care, correct?
it provided an hourly rate for the care, correct?
To Mr. Badger's wife, who was also the Realtor, correct?
She was the Realtor on an earlier transaction, yes.
Okay.
Yes, which Mr. Badger's attorney filed a motion to get approved. They had a hearing, but for whatever reason, there was never an order entered on that. Either way, either approving it or disapproving it. Basically, Mr. Badger testified that Judge Kirkwood said, go do what a judge, or go do what a trustee does. Judge Perry...
The lawyer didn't follow that up with an order, correct?
That is correct. Or the Herald's attorney did not follow it up with an order either. So both sides.
What I was making reference to is the care agreement defines Wilson as the trustee, Badger as the ward, and Badger's wife as the caregiver.
Okay, Your Honor, I think you're probably the first to have noted that, because I have not heard that raised in the trial that I attended. But if that's the case, it clearly would have been a scrivener's error. But Mr. Wilson testified at trial. He testified that he wanted Mr. Badger and his wife to provide services, that they indeed provided services. And more importantly, I think to Judge Wallace's question, he testified that he got the benefit of this money. We went through in great detail a number of different items, such as purchasing the trailer, such as purchasing groceries, such as paying his lot rent, his electricity, that he acknowledged the Florida Foundation paid for. In fact, even though the judge ruled that Mr. Badger had no further duty to account for the funds, once the Special Needs Trust was set up and the funds were essentially decanted into that, Mr. Badger, at his own expense, went to great trouble to get records from Ms. Littlefield and put together an accounting that accompanied our amended petition for discharge. And in that accounting...
Let me ask you, you indicated that the surety bond was eventually obtained, I think it was about a year after the August 2006 hearing, and that surety bond remained in place until this case was, the litigation below ended?
Correct.
Okay, and then it was discharged because the trial, Judge Perry found no liability on the part of the trustee?
That's right.
Do you agree with Mr. Wilkins' view? Let's assume hypothetically that we disagree with your argument that as a matter of public policy, there's this absolute immunity on the part of the trustee once they hire an attorney, and if we reversed and remanded it back, that the bond would be reinstated, and then the issues as to whether that bond should then cover any of these damages could be litigated below?
I would not concede that, Your Honor. I have not looked at that issue in detail, but the bond company believes they are discharged, and I think that it would be a surprise to them if they are later told that their bond has not been discharged.
Obviously, it'd be a surprise to your side, too,
Yeah.
if that's what happened, but
Yeah.
is that, in essence, in other words, in essence, if Judge Perry had ruled adverse to your position, and that there was a breach of fiduciary duty, and Mr. Wilkins' side was then making a claim, saying, okay, you need to put the money back into the pot, for lack of a better term, wouldn't your trustee, Mr. Badger, then look to the surety company and say, well, you know, that's what I've been paying you premiums to cover?
No, Your Honor, the surety company, if they were made liable, and I do not know whether or not the bond would be reinstated, I haven't researched that issue, but if the bond, for sake of your question, is reinstated and they pay the funds to reinstate the money, then Mr. Badger is personally liable to the bond company for those monies. So it's not like an insurance. It's if they put out money, they're looking to Mr. Badger to pay it back.
Okay.
For those reasons, I ask that the court...
Just ask you one other question. Your client also has a $80-some-odd thousand attorney's fee judgment.
That's right.
And it seems to me, I mean, I'm trying to think of some duty that your client didn't breach, either intentionally, and, you know, if we accept your argument, he went to a bad lawyer gave him bad advice, and a lot of the money disappears. Nobody got notice that was entitled to notice. Accountings weren't filed on time. I'm having a hard time seeing what your client did right. Be that as it may, I'm trying to understand on what basis, you know, it seems to me that they were able to adequately demonstrate that the trustee didn't do what he was supposed to do. He got bad legal advice that he relied on, apparently, and all the money disappeared. The accountings weren't filed on time. The mobile home disappears. All this stuff happens, and yet they get whacked with $85,000 in attorney's fees. And I understand the way I read the statute on fees is the court can do essentially what it deems as equitable under the circumstances. And I'm trying to see how the equities, maybe your client gets off the hook for having to pay back any of the money, but I'm trying to see how any of the equities line up behind him getting fees paid by them.
Excellent question, Judge Orfinger, and the answer is because in the amended petition, we set forth out all the facts that were laid out at trial as to why this happened and the basis of why our client should be discharged. And that is we said, look, we were advised by Ms. Littlefield to set up a special needs trust. We were advised to take the sale proceeds from the house and put it in the special needs trust. We were advised that we were no longer the trustee.
They were just supposed to blindly accept all that?
Your Honor, they presented no evidence to the contrary. And the fact that we have a statute right on point, that's the 736-0816, that we can rely upon the advice of a professional should have caused them to not have pursued a surcharge against this trustee. They had everything they knew right from the beginning, including this full accounting where Mr. Badger accounted for all but $4,000 of how that $216,000 was spent. They had everything they knew at that point to say, look, there's no money left in the trust. If you go after this trustee for an error that his lawyer made, then there's going to be a lot of attorney's fees here expended. They were on notice.
Counsel.
Thank you.
4 minutes, 45 seconds.
Thank you, Your Honor. Let me go back to the attorney's fees question, and I completely agree with Your Honor. What else was the beneficiary supposed to do? We know he violated the decanting statute. He wasn't allowed to decant. He didn't give us any notice. What are we supposed to do? Get tagged, you object, you ask the court to determine whether the trustee should be surcharged, and we get whacked with $90,000 in legal fees? We didn't do anything wrong. All we did was object to the fact that he breached his duties and didn't account. And that's the other point. No one told him not to account. He didn't rely on advice of counsel not to account. He did that on his own. No lawyer told him, ignore the court order, ignore the trust code. He assumed that after he decanted, he didn't have to account anymore. Well, what about up to that point in time? He never accounted. He never accounted at any point until way after the fact. The other point that I think needs to be made is that the statute that's referred to is not an exoneration statute. If you read that, it says they don't have to go behind the experts, if you will, the advisors' conclusions, but you got to have an attitude of vigilance as a trustee. You're holding other people's money. You don't go around and if you look at the care agreement as a good example, you don't sign documents like that you know, and both parties, David and Mr. Badger, said at trial, we weren't going to comply with that. I never saw that before. I didn't really understand that. But this is Mr. Badger signing documents from a lawyer that he has never vetted, has no information about, and not even in the community where he lives. He goes out to Osceola County for this service, and he thinks, I'm exonerated. I'm completely exonerated. That cannot be the public policy of this state. We don't know whether Ms. Littlefield had malpractice insurance. That's the remedy if he gets to the point where he has to pay because he relied on her advice. Where's her malpractice insurance? She probably had some, and it probably still there. It's probably something that we could potentially have this trustee go after. But we as the beneficiaries can't go after that. We're not in privity with Ms. Littlefield. We weren't the parties she represented. We're not even beneficiaries of the trust she created. So there's no way for us to do that. There is a way for him to do that. So again, to think that this is somehow a get-out-of-jail-free card, that statute doesn't ever say that. And this court's going to have two new decisions of record, hopefully. Number one, what's the remedy when you violate the decanting statute? What's the remedy? And number two, is this statute that is supposed to be, as he claims, an exoneration statute as broad as basically a full exculpation whenever you do something wrong as a trustee? I cannot imagine that any treatise would ever suggest that that was the intention behind this statute. What this statute intended in the Lowell case that he's talking about is the question of whether we took a deduction on an estate tax return. Number one, the accountant was the decedent's former accountant, so it wasn't like they went out and picked a bad accountant to give him advice. And number two, in this case, he had no relationship with the Littlefields. He had no experience with the Littlefields. He wasn't even sent to the Littlefields by a lawyer. He was sent by somebody in his office who's not a lawyer and said, we had great experience with him. That's the basis of the vetting that took place. So I think what you've got to look at is whether this case would justify such a broad exoneration of a trustee who clearly breached almost everything he could breach. He didn't account. He decanted improperly. He never gave notice to the beneficiaries. He took fees that were unapproved by the court. He engaged in related party transactions. Think about this for a second. The payment of the commission to his wife was never approved by the court. His lawyer knew that had to be approved if they were going to engage in that transaction. His testimony, I was there, I won't testify, but essentially that's what the judge said. You need to do what a trustee needs to do, and I'm not going to approve this contract. So what does that tell Mr. Badger? He turns around a couple of years later and engages in it. I mean, nobody gave him advice on that. His lawyer actually told him not to do that. With that, my time's up. I would ask the court to reverse this. The only question is, if we have damages, do we have damages for the full amount of the decant, or do we simply use the actuarial tables, which are available, to determine my client's interest as remainder beneficiaries? And we'd ask the court to reverse the attorney's fee judgment entirely, because this is not the case where this should have been tagged against these innocent beneficiaries. Thank you.
Thank you.